Welcome to Getting Facts from Third Parties, FOIA and Other Avenues, sponsored by the ABA section of Taxation. If you are seeking CLE credit, you must attend the entire program. Partial credit is not available. Please click on all participation verification alerts during the program to confirm your attendance. Immediately after the program ends, a link to complete the certification process will appear. Please complete the evaluation and the CLE affidavit providing your bar information as requested. Once the completed form is submitted and your attendance verified, your certificate will be emailed to you. I would now like to turn the program over to today's moderator, Janice Shih.
Great. Hello. Thank you. I'd like to briefly introduce my fellow panelists. We're going to start with Elizabeth Maresca, who is a clinical professor at Fordham Law School in New York and the supervising attorney of the school's tax clinic. Professor Maresca specializes in federal tax controversy and litigation against the IRS and has advised clients, attorneys, and policymakers on the tax issues which arise in consumer matters. She is an expert on tax controversy matters, identity theft, innocent spouse relief, and tax issues that arise in debt collection, FDCPA, and foreclosure matters. Professor Maresca received her LLM in taxation and her JD from NYU. She'll be followed by Nick Lawton, who is a senior associate at Eubanks & Associates, PLLC, where his practice focuses on environmental law, administrative law, and government transparency. The child of biologists, Nick earned a JD and LLM in environmental law from Lewis and Clark Law School. His work generally focuses on promoting the protection of animals, such as endangered species in public lands, such as national parks. FOIA is also an important component of Nick's practice, with FOIA litigation representing about a third of his caseload. Many of these FOIA cases focus on requests that have languished before agencies, but Nick has also litigated several cases to enforce FOIA's mandate that agencies must make certain information available online without the need for any request. Our third speaker will be Teresa Trissel, who has practiced tax law with the federal government for over 18 years, first at the Department of Justice Tax Division and presently with the IRS Office of Chief Counsel, where she serves as senior technical reviewer focusing on disclosure law, FOIA, and judicial doctrines. Teresa received her BA from the University of Nebraska and her JD from Georgetown University Law Center. She previously lived in Brussels, Belgium for 3 years, where she earned an executive master's degree in finance and traveled as much as possible. So I would like to welcome all of our panelists and all of our attendees and turn it over to Elizabeth then. Let's start.
Hi, everyone. So you'd think I'd be getting used to these things without a live audience, but I am slowly getting used to them without a live audience. So I'm going to go through some things, and if people have questions, I'd like to answer them as I go along. So feel free to put them in the space provided, and Janice will let me know there's a question, and I'll answer it as we go. Okay, so just some background. A lot of times substantiation comes up for a lot of different reasons. And here, like, we have some things. People misstate their income. People misstate their deductions. Self-employed people don't always have records of how much money they got. Sometimes they're paid in cash. We have a lot of cases in our clinic where our clients receive information returns that are either false or very false or ridiculously false, and then we have to unravel that. So there's all these like automated audits your clients can get caught up into because of different kinds of forms, 1099s, 1099Ks, 1099 myths. We have work classification issues sometimes where we want to have the IRS treat the person as an employee instead of an independent contractor, and just like all those general issues. So I'm going to sort of talk about the various places you can get information to help your clients through all their cases, obviously, not just audit and deficiency cases. So I'm going to talk about third-party information, then I'm going to lead a little bit into information that the IRS has that you can get through FOIA. And so here we go. So basically third-party information. I made a big long list here of what you can get. most of our clients who come to us, they don't come to us and say, oh, this is my business and here are my business records, and they give you this nice big pile of business records. Often they have something that's partially helpful, but you wish there was more. So you normally, especially in low-income taxpayer clinics, you need to get creative with your clients to find out a way to document their business. Let's just say, and like for instance, we just had a person, and he basically, his side business is that he's a dumpster diver. So he goes to a place where I think they fix computers, or an office building, I don't know, and he'll actually go in the dumpsters, get out like computer equipment, and then try to fix it and sell it. So his deductions, okay, so he doesn't have a cost of goods sold because he's getting stuff out of the garbage, but he does have to get to the garbage bins, and then he does have other things that he has to buy so he can fix the computers. So, and then we had another woman come in, and she buys things off of eBay, and then she like makes them nicer and then resells them on Etsy, on her Etsy site. So I don't know that much about these two businesses, and normally what we would do is we'll ask the client, we'll say to them, can you take us through like one of your days? Like just take us through last Tuesday. What did you do last Tuesday? And we ask them a lot of questions. And with those questions, what we're trying to do is in our minds figure out what documents they may have to support, let's just say, their business deductions. So the easy ones are bank statements. You'll have deposit slips. You'll have copies of the checks that were drawn on the account. Credit card statements are easy. Places like Home Depot, if your client is a subcontractor or a contractor, many times they have their own account there. It's not connected to a credit card, but they'll have an account, and they'll be able to print you information from their account. Like for our Etsy person, we actually asked her for her PayPal records to see what she had purchased to use to build whatever trinkets, I don't mean to be disrespectful, but whatever widgets she sells back on Etsy. So, and if you don't know how to get those, like we just went on the internet and said like PayPal reports, and up comes a web page from PayPal about how you can print out your reports. And other things just like for children, the easy things for children to prove that children, birth certificates, school records. But a lot of times the client doesn't know what to get, so we may send them with a sample. To go to the maybe her doctor's office with a sample to get a letter back. We have people that come in who had Schedule D income from brokerage accounts and stock sales, and so you'll go back and get those statements. Spousal settlement agreements are good sometimes if you have an innocent spouse case. I had a client once where we were trying to prove something about his business, and it turned out on his credit card, he had like the parking meter stuff like right on his credit card. So we were able to go into his parking meter app and find out where he was parking, and that helped us determine where he was traveling to and from. So those are some kinds of things. And I have another slide here with some more documents that you can think about. We once had a client where we had a client where we were saying they were an employee and they had been issued a 1099 and the IRS wanted their self-employment tax. Well, it turned out when he got hired, they sent him an email with like an employment manual in it. And it was pretty clear from that employment manual that he was an employee. So things like that. Just other things to do. We have we recently had a nightclub singer, and she had a website where she advertised, and she did have good receipts. She had receipts for makeup and costumes, but she also had a website where she had like a demo of her music, and she had proof that she had performed at certain nightclubs in and around the city, obviously pre-COVID. And so, I think just by asking big, broad questions sometimes about their job, you can find out more information from them and sort of find the right documents to ask for. Okay. I'm going to talk a little bit about 1099-Ks because they seem to be more and more prevalent. We're getting a lot of calls from people who get them and they're not representative of their actual even gross income, let alone net income. So again, those 1099-Ks report the payment of credit card transactions or third-party network transactions. So when you go swipe your Visa at Target, that's going to come through to Target on a 1099-K from whatever bank issues your credit card. So just so you know, this is really relevant for like a lot of our gig economy workers, like our Lyft drivers or Uber drivers or Uber Eats or whatever that is, whatever those jobs are, because that's going to come through to them often on a 1099-K. And Uber is often reporting on those documents, not the amount the driver actually got, but the amount Uber actually got. So it includes the fee that Uber will take. It would include the tips. It might include the tolls and things like that the customer paid. So there's no adjustments for any kind of discounts or refunds or fees, so you want to be careful about that. So normally if you get anything with a 1099-K, you want to always think about that as a gross amount that's not representative of what your client got, and you're going to want to go back and get statements. Now, in my experience with Uber, going like 5 or 6 years back, their records were really bad, but more currently they're better. So you want to always see what your client can get directly from those companies, like what is in their like account, and then match it up directly with their bank deposits. So like the last Uber driver we had, the amounts reported on the 1099-K didn't match his bank statement. The amount reported on the Uber statement, the actual statement that they said they were paying him, didn't match his bank deposits. So what we were able to show was that, 1099-K money, there's no cash floating around here. So what we were able to convince the IRS that his bank statements were the accurate representation of his gross income, not the statements we got from Uber or the 1099-K. So you want to just be mindful of that and to go ahead and do the work, get the bank statements, and see what you can figure out on your own. Also, just to know, like for Schedule C deductions, sometimes you have issues of whether or not they belong on a Schedule A. Like a uniform or commuting expenses or travel and entertainment, just things to think about. I know we have no more miscellaneous itemized deductions, but some of us are still dealing in tax years from the recent past where a Schedule A miscellaneous deductions still count. Just those are just things to think about. Okay, so burden of proof issues. And again, a lot of times what we're doing here is not just recreating deductions, we're recreating proof of income, especially, like I said, as of late, we're getting a lot of these automated underreporter audits where the payor is reporting income that doesn't match with what our client is actually saying they got from their company. Okay, and then of course, those kinds of things have a presumption of correctness. You always want to remember about burden of proof under 6201D, which puts the burden of proof on the IRS for an information return where when you say that it's not your income. And so that's something else. And then also, just to go forward, when you're thinking about CDP hearings and innocent spouse hearings and overcoming the abuse of discretion standard in those cases, CDP cases, and also for innocent spouse, now we're bound by the administrative record. So, one of the things you want to do, and I'm going to just turn to information the IRS has now. One of the things you always want to do is get information from the IRS. We're going to talk more about Foia today, but I like to use Foia before I get to a point where I'm going to be able to ask an IRS attorney for discovery. And that's usually a long time. The client may come in, pre-petition in the tax court, or maybe the client comes in with audit reconsideration. Well, I want to get my hands on those IRS files because in my experience, IRS files, there's like gold. I always say there's gold. You're like digging for gold. You get an IRS administrative file, and sometimes you win your case just by reading the file. And I tell this story, and it's a true story, but I once had an innocent spouse case where my client was the victim of domestic violence, and the IRS innocent spouse file said, we're going to deny her innocent spouse request because the abuse started before she married her non-requesting spouse, and therefore we're going to discount the abuse during the marriage. So I was like, oh, I think I'm going to win this case, because I don't think there's any IRS lawyer that's going to tell that to a judge. So there's just, and then I have other cases in CDP where you look at if you look at the settlement officer's notes, they're actually like, they have the law wrong. Well, if you can prove that the person made their decision in a CDP case based on not the wrong law, they just had the law wrong. Well, I think that's, going to make your abuse of discretion standard easier to pass. So you really want to get those notes. So I put down here some of the basic things you're going to ask for in an audit case. Any kind of audit case, you always want the exam file. It may have old notices in it. Sometimes the clients come in and they say to you, I mailed all this stuff into the IRS and I never heard back. Well, if you do a FOIA request for that audit file, that stuff might actually be in the audit file that you get back, and you'll have copies of whatever your client sent into the IRS. And then for innocent spouse cases, again, the Pretty People's Notes, my view in innocent spouses, they pretty much say no to almost every claim that's made, but there could be good information in their notes. And again, same thing with CDP cases. So the next thing that I have done is I have put in here into the slides so that you'll have it, just some examples of the kind of things I asked for in a FOIA. And it's just like sort of canned language, but basically when you want an audit file, you ask for the whole examination division file. And again, this really helps in a lot of innocent spouse cases. My experience in innocent spouse is you've got to get the exam file, you've got to get the administrative file, and I have found so many times where the non-requesting spouse forged my client's signature either on some kind of settlement letter, some kind of agreement to the tax, and that is, or you can see from the notes that the non-requesting spouse was the only one who ever spoke to the IRS, that your client never spoke to the IRS. So in any innocent spouse case, I would always ask for examination division files. I know sometimes it's just an underpayment case and there won't be anything in there. But, if there is any kind of understatement, and anytime you open an innocent spouse case, you always want to get the exam file, because like I said, there's always good stuff in there. All right.
Elizabeth, I'm going to jump in real quick and just, there's a question about, in your experience, how long does a FOIA request take? I'm not sure if you're addressing this later, but...
In my experience, it depends on what you're asking for, so I know that's not a good question, but like an exam file shouldn't take that long. You could get it within 2 months. So I've had cases that I've gotten all the information before I had to file the petition in tax court. Or my client comes in and I know I want to do an innocent spouse request, like an 8857, and I'll ask for the exam file, and it'll come in while I'm still preparing the 8857 with the client. So it's never too late to ask also, because you can always add information later. In an innocent spouse case, if you do the 8857 right away and you ask for the exam file and stuff comes in, you're going to be able to use that during your appeal. So like in my experience, again, it depends. Like one time I asked for something and the IRS, I think they didn't want to give it to me, and they just kept saying, we need more time, we need more time, we need more time. But the other panelists are going to talk about that more. So is there anything else? Janice?
Sorry, I had to unmute myself. So I think we do have a question about has anyone been successful in getting emails between managers and employees? So I guess it's for like an employee, and I guess maybe an internal communications in a business.
Okay, so I'll let Teresa speak to that during her part. But my experience is sometimes, yes, it will come in with, those things will come in. Like I just had in an innocent spouse case, when we got the exam file, I actually got the emails between the revenue agent and the IRS counsel, when he was preparing his revenue agent's report, he had questions. So I got some stuff from that. So I guess that depends. I think once you're dealing with, you know, obviously the government has certain kinds of privileges that they're allowed to you know, to use to not give you stuff. But so I think again it just depends. But I have gotten emails, maybe not the specific ones that you're asking for in this question. Should we keep going with these questions?
Yeah. Oh, well, here's a
yes,
question that
let me do number 7. So in number 7, someone's asking me, why must the attorney for the taxpayer rely on FOIA to get the file? Wouldn't we be entitled to it akin in discovery litigation? Yes, you would be entitled to it. But I've had experiences where I asked for stuff in informal discovery in tax court, and the IRS counsel's like, okay, well, you can come sit in my office. And I sit in their office, and they turn pages, and they don't give them to me. But when I ask for a examination file from the IRS in FOIA, I get the entire file minus whatever they think I'm not entitled to under the law. And it comes in faster, and I just think it's better. So you can do it in the discovery way, or through informal discovery. I just think FOIA is faster and simpler, and then I don't also have to wait until my case gets petitioned. I file my petition, and the case gets answered, and the issues are joined. And then I'm in appeals, and so I just think it's faster and more complete. But that's my one person's opinion.
This is Nick. I'll follow up on that and observe that, at least in some instances, it seems like getting information faster through FOIA might allow you to preclude the need for litigation altogether. You might be able to contact the agency and say, hey, I got this information through a FOIA request that, you know, renders these issues null. And you might save yourself and your client the burden of going through the litigation process.
Yeah, certainly, like if you're just, if you're in appeals before you're even going to do informal discovery and you have the file already and you're talking to the appeals officer, it certainly can get wrapped up in appeals quicker. Someone's asking if you need an audit automated under report or admin file. Yes, you use regular FOIA. You just do a FOIA request. This slide here that I have actually up right now is for an audit file. Let me, Janice, is there anything more in there?
No, I think we can go ahead and continue. Some of these questions right now may be better addressed by Nick, or perhaps might be addressed as we go along. So thank you, Elizabeth.
Okay, sure. And the next one is just for the CDP file. Again, CDP files, your burden is abuse of discretion, and you really want to know what the settlement officer or appeals officer was thinking when they were making their determination. And in their notes, they have to keep notes to their file. They will type in what they're thinking. And when you see that, you're going to, it's going to give you more information about how to best represent your client. Should you not be able to, settle it in the CDP? Like if you're in tax court, you really want that information. I think a lot of IRS people are busy, and sometimes they make mistakes, or they're rushed and they make mistakes. And so if you can figure out that they made a mistake, that's like going to make your life easier. And again, like what Nick said, like if I see a mistake in a CDP file, I'm going to just petition that case. I'm going to talk to the IRS lawyer. I'm like, can we resolve this? Look at this mistake they made. And they'll look at it and they'll resolve it with you. It's simple. It can be simpler. All right, and the last one I put up here is just for innocent spouse. And again, innocent spouse, I think CISO stands for Centralized Innocent Spouse something, but when you ask for those work papers, again, you get all of the information the IRS did with your innocent spouse case. And you really want to, I think, get that information before you're, during the process. If you can get it before you have to petition the tax court, I think that will help you draft your petition. And like I said, sometimes if you get a final determination and you do the FOIA request, that stuff may come in before the time your petition has to be filed. So anyway, I just put this sample language in here for people if they want to use it. Someone asked a question about state and the federal government. I mean, I think they're a little different. Normally, when I ask for stuff from the IRS, they just email it to you, or they mail it to you, or they the state will sometimes actually, New York State will sometimes actually call me and say, okay, what do you really want? But I don't have that experience with the IRS. I just ask for the stuff, and then the stuff comes. And I guess that's it, unless there's any more questions in there for me, Janice.
No, I think, so the question was about whether or not there was any state level experience. And I guess there's a question about FOIA versus the Privacy Act. Nick, are you going to speak on that then, or I'm not sure I understand what the Privacy Act is.
So the Privacy Act allows people to request information about themselves, essentially. This is a little bit outside my purview, since I typically represent people who are looking for information about federal agency actions. But they are closely related. They are both mechanisms to obtain information from federal agencies. My understanding is that you can submit one request that operates as both, although I don't know if the IRS has sort of a seamless mechanism for doing that. I hope that provides some clarity, at least.
Okay, great. Okay, and then I think the next question would be, to whom should the FOIA request be directed?
I will definitely be covering that.
Okay. But anyway, let me just add really quick. If the IRS makes it really easy, because they put right on their website where you're supposed to write to, and it does change. So before you send one out, jump to their website, check the address, and make sure you're sending it to the right place. But I don't know about other federal agencies, but they make it really easy to find out where it's supposed to go.
Okay, well, I guess I will go ahead and move on to providing an overview of FOIA. So I'm going to cover at a 10,000-foot level how FOIA works, what you can expect when you file a FOIA request, and some best practice tips. And this is essentially the same slide, so I will just move on. So at a 10,000-foot level, FOIA's basic purpose is to open agency action to the light of public scrutiny, as the Supreme Court said. Another way the Supreme Court has phrased it is to allow the public to know what the government is up to. So more particularly, it requires agencies to produce certain requested information with 9 specific exemptions. Those exemptions are supposed to be construed narrowly because the dominant objective of the statute is disclosure rather than secrecy. When an agency receives a request, it's supposed to respond within 20 working days. There are also categories of information that are supposed to be made publicly available without a request. These include rulemakings, these include certain types of frequently requested records, but I think it is relatively unlikely that that will be germane to the people on this presentation, so I will focus instead on actual requests directed to agencies. So here are the 9 exemptions that FOIA establishes. So these are information that does not have to be produced. I have included in boldface the exemptions that the IRS has identified as those most frequently invoked. So those are information specifically exempt from disclosure under another law, such as laws making tax return information confidential, information protected against invasion of someone else's privacy. So if you ask, for example, for someone else's tax returns, you might run into that exemption. And information compiled for law enforcement purposes. And that has a variety of sort of subparts. But you might see if for example, the IRS is already engaged in a law enforcement investigation and you file a FOIA request, you may see some of the information pertaining to the investigation withheld from production. There are also a bunch of ones that I seriously doubt will be germane to the IRS, such as geological information on wells. I doubt that will come up much. But I have put in italics too that I see come up and that are in some sense a moving target right now. These are trade secrets and confidential commercial information and privileged information. And the privileged information includes attorney-client communications or deliberative information. And deliberative information is information that is an inter or intra-agency communication that comes before a decision and reflects sort of the drafts or initial deliberations of agency officials on an issue. Now, the reason I say that these are, in some sense, moving targets are that the Supreme Court is either currently considering or has recently handed down a decision that alters the tests for when these exemptions apply. So in, I believe, 2019, the Supreme Court handed down a decision called Argus Leader that scrapped, frankly, decades of case law about what constitutes confidential commercial information and has left the legal landscape in some disarray, with lower courts a little confused, frankly, as to how to determine when information is protected by that privilege. And then currently before the Supreme Court is another case about whether draft documents are protected as deliberative privileged information. So we will all sort of have to stay tuned to see what the scope of that exemption is moving forward. But these are the basic categories of information that agencies do not have to cough up in response to a FOIA request. When an agency withholds information like this, you will typically see that when you get back a response, right, which will either be in paper or these days more often in a PDF email, entire pages may be withheld or portions of pages may be withheld, and they'll be blacked out and labeled with the appropriate exemption. So they may withhold, for example, an entire document saying, this whole document is protected by the attorney-client privilege. And that's sort of mechanically how you will know what exemptions an agency has invoked. So here, where to submit a FOIA request, sort of getting down to nuts and bolts. The federal government has created a website that is sort of a centralized clearinghouse for FOIA requests. It's foia.gov. My understanding is that the IRS can and does receive FOIA requests through foia.gov. And foia.gov is fairly navigable. It features a series of drop-down menus and fillable fields that you can use to select the appropriate agency to which you're directing the request, and will prompt you to provide the necessary information. The IRS specifically also provides guidance. I've linked a website here, as well as the citation to the IRS's FOIA regulations. So that's worth looking at if you are contemplating filing a FOIA request specifically to the IRS. I've also provided a fax number that you can find on the IRS website. So that's sort of mechanically where you go about submitting. You can also do it by mail, hassle, and many agencies sort of regard that as obsolete these days. And I personally prefer to use foia.gov or a fax. Some agencies also receive them through email, although there appears to be sort of a movement away from that. So in terms of making a FOIA request, one of the duties that the requester has is to reasonably describe the records. That's straight out of the statutory language. And the test here is basically whether the agency can figure out what you're looking for. And that's articulated by the DC Circuit there. You can't just make a broad, sweeping request that is either unintelligible as to what you are looking for, or that would require an extremely burdensome response from the agency. So, for example, saying, I want all of the tax returns that the IRS has processed since 1969, would probably not be construed as a proper FOIA request. But the kind of language that Elizabeth flagged earlier, I think would be just fine, and apparently has indeed worked. There are a couple of wrinkles if you are making a request to the IRS specifically. And these have to do with proving your right to specific information. This is because by statute, Congress has made certain tax information confidential, so that if you are requesting it through FOIA, you should provide upfront information that shows that you have a right to what you are asking for. And here are examples. These are all drawn from the same IRS website that I linked earlier. And this is a little unusual. Most agencies don't require things like this, but most agencies don't have such sweeping confidentiality guarantees applied through statutes as well. So is it free? So no, FOIA is technically not free. You should be psychologically prepared to pay some kind of modest fees. And some agencies will require you to provide some assurance up front of your willingness to pay fees, particularly for voluminous requests. There are three kinds of fees that agencies can charge under the statute. These include copying fees, which is almost obsolete now that everything is electronic, search charges, and review charges. Often, a requester with a sort of a normal scale FOIA request, i.e. not something extremely voluminous, will not face fees because agencies generally do not charge fees if the total is less than $25.
Can I jump in?
Yes, absolutely.
Thank you. It's Elizabeth, everyone. So I almost never get, almost everything is emailed in a password protected thing. They'll send you the password in a separate letter, or they'll mail you a disc, and then you'll get the password in a separate letter for the disc. I almost never get charged from the IRS for FOIA. I did recently get a response that was like over 3,000 pages, and they charged us $25. And I always put in my letters, and this might be helpful for the low-income taxpayer people out there, that I'm willing to pay up to $150 for the FOIA response, but if it's going to be more, that they have to contact me. Sorry if I stole your thunder there, but they don't usually...
No, that's a wonderful practice tip. And you definitely, that is fair game. You can tell any agency, not just the IRS, how much you are willing to pay, and they will get in touch with you if the fees go above that. There are also fee waivers available through FOIA. There is a statutory test, and agencies have promulgated agency-specific regulations for the criteria for fee waivers. You should be aware, if you are requesting a fee waiver, that your request should be highly specific and should closely track the language of the agency's particular regulations. And the reason for this has to do with the standard of review. Although courts review the denial of a fee waiver de novo, the record for it consists solely of the information that you put before the agency when requesting the fee waiver. So if you come in with a sort of a shabby, cursory fee waiver request, the agency says no, you will not have an opportunity to rehabilitate your fee waiver request in court. So it's important to get any information that you want to put before the agency in deciding the fee waiver issue before the agency up front. Finally, the statute provides sort of an incentive for agencies to process FOIA requests promptly by forbidding agencies to charge certain types of fees, search fees, if they miss the statutory deadline for response. So if the agency takes more than 20 working days to respond to a request, it can no longer charge search fees. And this happens a lot. So once you've made a request, here's sort of the nuts and bolts of what to expect. Typically, an agency will get back to you, usually by email, and will assign your FOIA request a tracking number. Theoretically, the agency must also determine whether to comply with your request within 20 working days. I say that that's theoretical, even though it is a statutory requirement, because that's an extremely difficult standard for agencies to meet as a practical matter. And very often, agencies blow the 20 working day deadline. But what the statute requires is that they must determine whether to comply within 20 working days. And this means that the agency does not necessarily have to actually cough up the information within 20 working days. Instead, what it means is that the agency has to tell you what it is going to give you and what it is going to withhold within that time frame. And production can take somewhat longer, although that's subject to sort of a reasonableness requirement. So the DC Circuit articulated what the agency has to do, and that is to inform the requester of what documents it will produce and what it plans to withhold. So that's, you've got this sort of theoretical 20-day working day timeline. It often will take a little bit longer than that. And essentially the agency is either going to cough up all of the information, deny your FOIA request altogether, or do something in the middle, which is cough up some of the information you've requested and withhold some other information. So how do agencies do with this? Sorry, go ahead.
Oh, I have a question regarding the time frame. Has that changed significantly with the pandemic? I know everything else seems to have been slowed down significantly. So what would be sort of a reasonable expectation during this time frame?
Yeah, that's a great question. So of course, the pandemic has not changed the language of the statute, but in practice, it is taking agencies longer to handle FOIA requests, whether they are being handled in court or out of court. And so I've seen some courts be a little more lenient in regulating the pace at which agencies must proceed due to the pandemic. And a variety of agencies have also put out public guidance essentially saying, we're doing the best we can. A bunch of our folks are working from home. Our software doesn't work great for people working from home, and it's going to take some extra time.
Nick,
sorry, go ahead.
This is Teresa. Just to add on to that, the IRS is in that situation, as well. People are working remotely, paper files are in the office, and so on. So yeah, it's a problem.
Yeah, it doesn't technically change what the law requires, and it doesn't technically change, for example, if an agency blows the statutory deadline, you are considered to have exhausted your administrative remedies and you can sue. So notwithstanding the hardship associated with COVID, if the agency blows the 20 working day deadline, you can file suit. But, rushing to court like that does not necessarily look particularly reasonable to a reviewing court. And, I would caution some realism and prudence in thinking about when you may actually wish to file suit. Even in the best of times, outside of a pandemic, a 20 working day deadline is extremely challenging for agencies. Congress has, in some sense, given agencies at least a very difficult, if not an impossible task, because they have this mandate to produce a large volume of information which must be reviewed to determine whether information is exempt under exemptions which have a bunch of moving parts, and agencies generally do not have the funding to hire staff that is adequate to the task. So this is difficult for agencies. And if you are a FOIA nerd like me, you will find the FOIA statistics that agencies prepare in annual reports interesting. And they will largely bear out that this is very difficult for agencies to do. The IRS itself actually fares pretty well in comparison to many federal agencies. So the most recent available report for the Treasury Department shows that the IRS processes most simple requests in 1 day. Complex requests take an average of 39 days, and those granted expedited processing are completed in an average of 24 days. So this is actually pretty good, notwithstanding the fact that both the complex and the expedited processing technically violate the statutory deadline. In practical comparison to many other agencies, this is a pretty good track record.
Can I ask a question?
Go ahead.
Yeah, please, go right ahead.
About expedited processing, can they can charge you more?
No, expedited processing doesn't incur additional fees, but it does require you to make a certain showing, which is established both in the statute and in the agency's regulations. And as a practical matter, it can be relatively difficult, and the remedies, if the agency does not grant you expedited processing, are fairly limited. So if you are denied expedited processing, you can file suit, but your practical option is to seek a preliminary injunction compelling the agency to actually process your FOIA request more quickly. And that is often a burdensome and costly undertaking that many members of the public don't see the benefit of. So I think filing a request for expedited processing and paying attention to the agency regulations for what you have to show is a good idea. But you should be aware that in the event that it's denied, your procedural recourses are often going to be less satisfying than you might like. Moving right along. So if the agency
I'm sorry.
Sorry.
I do have a question.
Go right ahead.
That might be helpful to finish this. So the question is, how do you measure the 1, 24, and 39 days? When it, for example, the processing, when does that actually start? Like when does the clock start ticking, I guess, for that 1 day?
The
like,
clock
is it...
starts,
Mm-hmm.
Sorry, yeah, the clock starts when the agency receives the request, is my understanding, although Teresa may have more information about that.
Yeah, no, that's exactly right, Nick. I'll give kind of an inside view on what happens when the IRS gets your FOIA request, and there's a specific time where the FOIA request is date stamped, and that's your date.
And there is often a slight lag period, in my experience, between the date that you submit a FOIA request and the date that the agency states that it receives a request, which I understand just to be the matter of overworked employees not being able to open all of the requests necessarily on the day they arrive. So I typically see, plus or minus 2 or 3 days between when I actually click send and when an agency says, yes, we've got it. So unless there are any other questions on that, I'll move along to what happens if the agency withholds information from you. And this is sort of presuming that either the agency has acted in a timely manner and complied with the statute's deadlines, or that you've just sort of been patient and held your horses until the agency responded. In either event, if the agency responds to a FOIA request by withholding any information pursuant to one of the 9 exemptions, before filing suit, the requester has to pursue an administrative appeal. Congress recently, 2016, extended the time period for an administrative appeal. So requesters now have 90 days to submit an administrative appeal. Agencies, just like responding to a request, agencies must respond to an appeal within 20 working days as well. When preparing an appeal, it's important to look at the regulations of the particular agency you are working with. Those regulations should give you information about what particular information the agency believes must be included in the appeal, as well as other mechanical information about, where to submit it and information like that. So I've provided a citation to the relevant regulations for the IRS, but if you're working with other agencies, I just encourage you to look carefully at those appeal regulations because sometimes there's some surprising requirements in there. Now, in a more common situation, FOIA requests fall into what I sort of call the FOIA black hole. You send off a request, you get a tracking number, and that's all you get. And you're left with sort of silence for some period of time. And if the agency doesn't respond in a timely manner, your recourse can be filing suit. There are sort of pros and cons, of course, to filing a FOIA case. The major pro is that it will bump a languishing request up in terms of the agency's attention to it. However, rushing into court may not be the best strategy if you are hoping to eventually get a court to be sympathetic to your client. As a practical matter, looking like the most reasonable person in the room is helpful. If you are asking a court to review, for example, the validity of withholdings, and it helps to show that you had a reasonable process of engaging with the agency. So if the agency blows the deadline, I prefer to follow up with a letter to the agency advising it that it has missed the deadline and that my clients are contemplating litigation, but that we hope to resolve this without the need for it. And this can be effective. It is not always effective, but I find that as a general matter, the more that you engage in that kind of process, the more you are likely to shake loose, even if it is only information from an agency about when it actually is going to get around to responding. This can also be helpful for eventual fee recovery, which I'll talk about in a little while. So presuming you do file a lawsuit, here's what a normal FOIA case looks like to the extent that such a thing exists. Typically, FOIA requester will be challenging the agency's failure to respond at all, right? You will file suit before an agency has given you any information whatsoever. In such a situation, which is, in my experience, the most common type of FOIA litigation, it's important to tailor the complaint well so that you avoid the need to file an amended complaint later. So if you just file a complaint saying the agency didn't respond to my request, that claim can be mooted by the agency responding to your request. But if you challenge the failure to actually produce all responsive non-exempt information, then your complaint will be valid and operative for the entirety of the FOIA litigation. So that's an important best practice tip. So a normal FOIA case will then be put into what I call the production phase, and this is where an agency, typically under a court order, will be reviewing the information that it has gathered in a search in response to the FOIA request, and will typically on a monthly basis review a certain number of documents and send the requester and counsel a letter including what responsive information is being released that month. And depending on the volume of potentially responsive records to be reviewed, the production phase in a FOIA case can take months to years. So it can drag out, and common issues in the production phase are typically the pace at which an agency must review records. Once production is complete, I prefer to attempt to work out settlements of any remaining disputes. So at this point, the agency says, we're done looking for records, we've given you what we're going to give you, and you then have the opportunity to look at what information the agency has coughed up and to inform the agency whether you have problems with perhaps the scope of the search, if you think there's specific information that the agency hasn't turned up, or over certain redactions, if you think the redactions have been inappropriately imposed on certain information, and of course, settlement over attorney's fees. Many FOIA litigants recover attorney's fees. It's quite common for prevailing plaintiffs to recover attorney's fees, but it is also extremely common for that to be handled in settlement. So I typically, once production is complete, I like to at least explore the process of settlement before moving to summary judgment. If you do litigate all the way through your FOIA case, it will be resolved more than 99% of the time on cross motions for summary judgment. In summary judgment practice in FOIA cases, the government has the burden of proof, has to show that it conducted a reasonable search and produced all responsive non-exempt information. So the government files their motion for summary judgment first, accompanied by declarations describing the search, and then the briefing for cross motions and summary judgment ends with the FOIA requester having the last word. And of course, then it's up to the court to determine what happens. So that's sort of the mechanics of a normal FOIA case. Well, I guess I just sort of went through this, didn't I? So this is a little more information about summary judgment. I guess I will delve a little bit more into what the agency actually delivers in terms of proof. So agency declarations describing the search have to be sufficiently detailed and specific for the reviewing court to understand what the agency has done and determine whether it was reasonable. So that has to identify, for example, where the agency looked for records, and often in response to a requester's legal arguments, agencies will file supplemental declarations explaining, for example, why they didn't look somewhere else that the requester thinks they should have looked. Additionally, where an agency withholds records, it has to produce what is called a Vaughan index. And that Vaughan is the name of a case that came up with this requirement. And the Vaughan index is a document that describes briefly what information has been withheld and the basis for that withholding. Of course, that description is not so detailed that the requester knows exactly what has been withheld, but it is supposed to be sufficiently detailed and informative for the court to be able to determine whether the application of a specific exemption was reasonable. Now, generally, in FOIA cases, discovery is not available. It is only in the truly exceptional case that a FOIA litigant is able to take discovery. This is the most common basis for that, which is itself extremely uncommon, is upon a genuine showing of agency bad faith. That, of course, is a very difficult thing to prove, and most often discovery requests in FOIA litigation are denied. So that's some of the mechanics of how FOIA litigation actually wraps up. Here are the most common issues that I've seen arise in this kind of normal FOIA litigation. And these are the adequacy of the agency's search, the reasonableness of the withholdings, and attorney fees. So in terms of the search, the agency has to show that it conducted a search that was reasonably calculated to uncover all relevant documents. It has to follow through on obvious leads. But the test is one of reasonableness. It doesn't actually require the agency to produce all information that might potentially be responsive. So, common issues that show up are, why did you only search this custodian's records? Why didn't you search another person's files? Why did you only search one particular database and not another? Or, for example, how did you construe the request when coming up with search terms? These are the kinds of issues that often get briefed in terms of the adequacy of a search. The reasonableness of withholdings are also fair game in FOIA litigation. I will let you know that FOIA is its own specialized beast. Each of the FOIA exemptions has standards that have been developed through decades of case law. Some of them, as I alluded to earlier, are rapidly changing. So I counsel that if you are thinking about, challenging particular withholdings, it's something that you should research carefully or talk to a FOIA specialist about. And then finally, of course, attorney's fees. FOIA does have a fee shifting provision. I believe I have a slide specifically on attorney's fees. Yes, indeed. FOIA's fee shifting provision specifies that as long as the requesters substantially prevailed in the litigation, they are eligible to recover attorney's fees. And this involves either getting a court order or, an enforceable agreement like a consent decree, or getting the agency to voluntarily change its behavior. So importantly, you do not necessarily have to get a court order at summary judgment in order to be eligible to recover attorney's fees. Instead, the most common question is whether the FOIA litigation was the catalyst to getting information that you would not otherwise have gotten. So basically, the question is whether the litigation was necessary. A common defense that agencies put forward is essentially they were working on it already. You did not need to sue them. You would have gotten your information in the same kind of time frame of the litigation. So in order to best preserve your client's eligibility to get fees, it's important to build a record for why litigation is necessary. This is another reason that I recommend that when an agency has blown a deadline, you send some letters to the agency saying, hey, you missed the deadline. When are you going to cough up records? And if the agency doesn't respond to, for example, several of those letters, it helps build a very persuasive record for the reviewing court that the agency wasn't responding until litigation was filed. And that is very helpful in getting the court to determine that, yes, you are eligible for fees. I also recommend pushing back on redactions. I think it is relatively common that agencies are a little overzealous in redacting information, and pretty frequently in my FOIA cases, I see redactions that I think are not especially reasonable or not well justified, and I push back to get the information that my clients are looking for. And I would say more often than not, agencies are willing to cough up more information once you push back. And this is valuable in two regards. One, it gets your client more of the information that your client was seeking. And then additionally, it shows that the litigation resulted in the agency divulging more information than it originally intended to, which also bolsters your claim for attorney's fees. So moving back to sort of the 10,000-foot view, in my view, as a sort of a big picture takeaway, FOIA is a very powerful tool that can be used very fruitfully in this context with the IRS and in many other contexts where you may have clients that are engaged with federal agencies. Where agencies are laggardly in responding to a FOIA request, which can occur, either through, just good faith being overworked and understaffed, or because agencies do not wish to cough up sensitive information that people are requesting, FOIA litigation can serve as a spur to get more timely responses and to shake loose information that an agency otherwise does not wish to provide. As a final matter, I'll reiterate that FOIA litigation is a specialized practice. There is a very large body of case law. It's important to keep up with recent changes. It should be accessible to the public. So this is not something that I think people should balk at utilizing, but if there are more complex issues that do arise in FOIA litigation, you should be aware that there are many attorneys who have sort of a specialized FOIA practice who will either be able to consult or handle FOIA litigation. I see that there's a bunch of questions that have come up while I was talking. I have not read them, so I'm not sure, Janice, if you would like me to answer any now or defer to Teresa.
Thank you. Thanks. Yeah, I think that many of these questions seem to be specific to tax, and since since Nick, you were so kind as to step into tax arena, we're not going to force you to answer tax questions. We'll leave those for Elizabeth and Teresa, I think. So why don't we move ahead with Teresa's portion, and perhaps we can circle back if we have time to answer these questions. Thanks.
Great. So Nick and Elizabeth have given you a lot of good information about when you're going to want to use FOIA. So I thought I'd start off by talking about when you do not need to use FOIA in order to get records from the IRS. So not every request for IRS records needs to be made under the FOIA. You can get a lot of information outside of FOIA from the IRS. And the most common ways that people get information this way is using routine established agency procedures, asking the IRS employee who's working the case, and then taking advantage of the new provisions in the Taxpayer First Act. So there are several categories of documents for which the IRS has established routine agency procedures. And a list of these items is set out in the regulations in 26 CFR 601.702D. It's also listed on the IRS website. The regulations list 9 categories of documents, and if you take a look at this list, you'll see that several of the items are now being made available proactively, and they're being published on the internet. So, for example, comments to regulations, notices of proposed rulemaking are published, usually on regulations.gov. Another example are written determinations, and that's a term that's defined in Section 6110 of the Code. Those are published in the IRS electronic reading room. So here's a picture. I just thought it would be interesting to show you what you would see if you go to the routine access link on irs.gov. And I've put big red arrows by the 2 items I think will be of most interest to this audience. The first is how to get a copy of your tax return, and the second is how to get a transcript of your tax return or accounts. And I'm going to make a push here for folks to take advantage of the Get Transcripts tool. A transcript of your account or return is free, and in many situations, it will work as a substitute for an original return. For example, colleges and loan originators will generally accept IRS transcripts. It's a super fast process. You can get it online, or if you have 5 to 10 days to wait, you can have the IRS mail you a hard copy of it. But it gets you what you want. and you can get it faster. The second way to get documents from the IRS outside of FOIA is just ask the IRS employee who's working your case or your client's case. IRS employees are empowered to respond directly to certain requests for records, and taxpayers are not required to go through the FOIA process to get copies of documents in their open tax administration files. So this option would include cases in various phases such as collection, examination, appeals, and any other open administrative case where an employee is working with the taxpayer directly. To encourage transparency in the administrative process, IRS employees are told to respond directly to taxpayers and provide as much information as they can without requiring the use of FOIA. And the third item to mention is a recent change Congress made in the Taxpayer First Act. Congress directed that taxpayers shall have automatic access to non-privileged portions of case files at least 10 days before appeals conferences. This is more of a subset of my previous slide, but I think it's interesting to note because it's fairly new and it's rather specific given the various categories mentioned earlier. So I thought it'd be interesting also to talk about what happens on the IRS side when you submit a FOIA request. And if you're a FOIA nerd like Nick and I, and you want all the details, feel free to look at the Internal Revenue Manual. It's available online. Look at Part 11.3.13, and we call the Internal Revenue Manual, we call it the IRM. The IRM provides direction and guidance to IRS employees on how to do their job. And this section describes how they should handle a FOIA request. So the first step is it's assigned to a disclosure manager, and this is your IRS contact. If you have any questions about the status of your request, or conversely, if the IRS needs to talk to you about the request in order to determine exactly what the records are that you're seeking. The IRM describes 5 steps that disclosure managers follow in working FOIA requests. When the request first comes in, it's date stamped, and Nick and I were talking about that earlier, and that's kind of when the clock starts, and it's put into the management system. And then the disclosure manager does an analysis, makes sure that it's an appropriate request under FOIA. She's considering whether it meets the requirements of the regulations. She ensures that it's in writing, that it's signed, that it states that it's being made pursuant to FOIA, and that it reasonably describes the record sought. So usually requests that are for all records concerning me or all records containing my name are not specific enough to process because they don't reasonably describe the records in sufficient detail to allow the employee to conduct an appropriate search. So it's important to specifically identify the records that you're looking for. Elizabeth showed some slides that, describe the exam file, for example. The file is an actual tangible thing, and it's clear what you're looking for if you use language like that. But requests for all records are generally going to be too broad and are going to be rejected as imperfect. The disclosure manager also checks over the request to make sure it provides an address for the response, that it states the requester's agreement to pay for the search, review, and reproduction charges as applicable, and that it contains an attestation as to the status of the requester. So, for example, is it a commercial use requester, a media requester, or other? The next phase in what the IRS does is the search phase. So the disclosure manager will reach out to the various offices and make sure that a reasonable search is done to locate the documents requested. The first thing they do is they determine which offices are likely to have responsive records. And then they contact the appropriate personnel and ask them to find the records. So each office in the IRS will have staff that are designated as the contact for disclosure. And disclosure is going to provide a copy of the FOIA to their contacts and say, please look for records and send them back to me. And this might take a while. And as we discussed during the pandemic, if the paper files are in closed record, federal record centers that are closed and aren't open, that might add a little bit more time. The next stage is the review stage. In this part, the disclosure manager applies redactions to the records that have been sent back. And the most common redaction for the IRS is the confidentiality redaction. It's under 6103. 6103 will be claimed if the information being denied is return or return information of someone that is not the requester. So this is not a discretionary redaction. 6103 is statutory law, it's a part of the tax code, and it provides for penalties for the unauthorized disclosure of return information. So this redaction is going to be applied even if there is no foreseeable harm. The final stage is the response and closing. Hopefully responsive documents are sent out and the case is closed. It's very likely that if there is a delay for the disclosure manager getting the documents, you're going to receive interim response letters. And if you see those, they'll say, we need more time. Don't get frustrated. It means the IRS has your case and the IRS is working on your case. It's just they need more time. I think administrative appeals were already covered. You can use this if you disagree with the IRS's response. It's a fast process. Appeals has 20 days to respond. And if the appeal is denied, even in part, the requester can file suit against the agency in the U.S. District Court. The requester has to establish they exhausted their administrative remedies and the suit is brought against the IRS. So I'd like to talk a little bit about judicial remedies because this is where I do a lot of my work. The best practice, in my opinion, is before you file suit, contact the disclosure manager. As Nick pointed out, attorney's fees are based on facts and circumstances, and there will not be an attorney's fee reward due if, as it turns out, recourse to the judicial system was unnecessary. Where the lawsuit did not cause the agency to release documents, the requester does not substantially prevail for the purpose of awarding attorney's fees. And again, the finding has to be that the lawsuit was the catalyst for production. So if you're getting these response letters, that's an indication that the IRS has received it and that they're working on it. And the IRS, does this a lot, and they've gotten pretty good at it. So I thought I'd point out just a few things from the annual report that Nick and I and other FOIA nerds like to peruse late at night. So in FY19, the IRS processed just over 8,000 FOIA requests, and the response time for simple requests was less than a day. That was both the average and the median. For complex requests, the median number of days was 20 and the average number of days was 39. So IRS gets on the FOIA requests in a timely manner, and it might be an uphill climb to get attorney's fees against the IRS. But maybe you can get more information by challenging the exemption. It really depends on the exemptions that are being claimed. And as was mentioned earlier, the most common exemption that the IRS uses is under B3. It's 6103. This is used a little under 2,000 times in FY19. And as I mentioned, that's a statutory exemption. It's not discretionary. I thought it was interesting, this is also from the annual report, the number of appeals processed and the number of times the agency was affirmed. So, it's a pretty good record, and obviously these appeals are not all are not all exemption appeals, but I think it demonstrates the point that overall the IRS is doing a fair job, at least in the eyes of appeals. So challenging the search, there's a reasonable standard. As was mentioned, the IRS must show that it has conducted a search that's reasonably calculated to uncover all relevant documents. And what does this mean? Does it mean the IRS has to look in every possible place for your document? No. And FOIA does not require an agency to exhaust all possible files which conceivably could contain relevant information either. So I'm going to just kind of skip through some of these kind of quickly. I want to talk a little bit about government declarations because there are several cases where litigants are trying to challenge the adequacy of the declarations. And as Nick covered, when the government moves for summary judgment, it will submit declarations that discuss the search effort undertaken and address the redactions that were made on the documents. So in situations where the disclosure manager has lots of employees conducting the search, the government doesn't necessarily need to submit a declaration from each individual who conducted the search. The courts say the government declaration can summarize the search efforts based on the information obtained by the declarant in the course of their official duties. And this slide just has a few of my favorite court quotes up here, which you can peruse at your leisure. So this is more of a theoretical discussion, but I think it's a fun one to have. And Nick and Elizabeth, feel free to chime in if you want. So we were talking about whether you can get more information through civil discovery than you can through FOIA, and potentially yes. So the attorney work product may be limited in discovery if there's a compelling need shown by the other party. Also, disclosure rules under 6103 that I referenced earlier, they're different for tax proceedings than they are for FOIA. For tax proceedings, you look at 6103H4, and there's no similar provision like that for FOIA. And then conversely, can you get more information through FOIA than you can through civil discovery? And again, potentially yes. Anyone can use FOIA. You don't have to be a litigant. There's no relevancy standard. You don't have to say why you want a document. If the government record isn't exempt or privileged, you can get it. And there's no proportionality analysis like there is now in civil discovery. Also, there are limits on the amounts of discovery that you can do in the federal rules. And for those of you who work in tax court, discovery is also, limited there. So that takes care of my presentation. I thought maybe we could hit some of the questions, Janice, if you want to walk us through those.
Yes, thank you. Thanks for wrapping that up and leaving some time behind. We did have a couple of questions, which I know that Elizabeth has tried to answer some of them, but some of them might be also very helpful to get your perspective on. So I think one was whether or not a person could request all exam notes of a particular RA revenue agent or EO, examination officer, without need to identify the person being audited. For example, if I see a particular EO that seems to respond differently whenever a rep is involved, but by nature, my client's FOIA requests only involve cases where reps are involved. And I think perhaps we can clarify that a little bit more. Can one seek all notes of a particular EO without a need to identify the taxpayer?
No. If you look at 6103 and you look at the definition of return information under there, any exam notes are going to be specific to a specific taxpayer, and that specific taxpayer would be able to get a copy of those exam notes, but not anyone else. It's confidential. And even if you tried to redact it, the whole thing is return information. that definition under 6103 is so broad that it would just encompass the whole of the request. So there wouldn't be anything to produce.
Sure. Yeah, that seems very broad there. Okay. We have another question that sometimes I have been hesitant to file a FOIA when I know, e.g., that appeals will have the case shortly, as I don't want the file pulled from the AO, especially with Taxpayer. First Act can get much of it at this point anyway. Any thoughts on the impact of requesting a FOIA and the file getting pulled from the IRS employee working the audit or appeal, et cetera? That's an interesting question.
Yeah.
Will it slow them down?
No, I don't. Yeah. So I'm looking for the question. They don't want to use FOIA because they're worried. Here, wait, let me skim down.
Number 18.
Let me jump in, Teresa. I think what they're saying is, like, in my case, I ask for FOIA sometimes in an active case, and their question is that going to slow it down? Like, how could that possibly slow down the ability of the IRS to work on the case? Like, his case is going to appeals, let's say, an innocent spouse case is going to appeals, or a deficiency case, and I ask for the CISO work papers, or I ask for the exam file from FOIA. Is that going to slow down the process, is, I guess, the question.
Well, I suppose, you can't say absolutely yes or absolutely no. It's going to be case by case. It's a skinny little file that's going to take someone 5 minutes to, photocopy. Is it like boxes and boxes, and people are going to have to spend hours looking at the documents and redacting them?
So let me ask you this. Does the appeals officer actually take the actual file and send it to the disclosure office, or do they make a copy and send it to the disclosure office? Like, how does logistically does it happen? I do
not know that. Yeah, I don't know the answer to that question.
But anyway, I answered the question as I think you should ask for it, and because my experience, it doesn't really slow it down that much. But again, my experience is anecdotal, like in what happens in my cases. But I think the information is so valuable and will help you so much that it's worth it, even if it does. Maybe you ask for the file and now the counsel person wants another 30 days to answer in tax court. I don't mind that because I still think the information is so valuable to me.
Yeah, and if you've got the IRS contact, you don't have to wait for FOIA or do it through FOIA. You can just ask for it. So Elizabeth, I was interested in what you said during your presentation about why you ask for FOIA, because otherwise you don't get a copy.
I just feel like because tax court, when you're in tax court, the parties are supposed to conduct informal discovery, and you're in a working relationship with this person, you ask for stuff, and I just feel like it's more complicated to just actually just get a copy of the file. They want to know what you really want and why you want it, and in FOIA, I just get the file, and then I can look at it, and if I want more, because sometimes the stuff is redacted, and you maybe want more information, like Nick was saying, but then I can be like, okay, I want these pages that are missing, because they're important or I think they're relevant. So that's my experience, and people may have other experiences.
I was curious.
Go ahead.
Do we have to? Oh, I see.
Yeah, we do. Go ahead.
But I was just wondering if about Nick's experience with other agencies charging fees, because you guys were talking about, the IRS doesn't charge fees very often. I'm wondering if that's typical of agencies or is it unusual?
We're not going to answer it now. You're going to make the IRS start charging us fees, though, Teresa.
I didn't say that.
My experience is that fees are, in at least the requests that I'm handling, fees are often not charged. And this is most often because by the time a request comes to me, it has been languishing for far longer than the statutory deadline, meaning that certain kinds of fees are off the table. Where I am with a requester from the jump, I like to request fee waivers in an extremely detailed and specific manner and have a pretty good track record of obtaining them. But I typically represent nonprofits that are seeking information from agencies about sort of wide sweeping things that affect large numbers of members of the public. So the fee waiver is relatively straightforward and easy to justify. So I very rarely encounter situations where my clients actually are on the hook for fees.
Interesting. Thanks.
Yeah, with regard to, I thought the conversation about discovery versus FOIA was super interesting. I will say that in most of my cases, they're Administrative Procedure Act cases based on an administrative record. And I like FOIA because it puts you more in the driver's seat of what information you want, as the agency is in control of determining what belongs to the administrative record. This allows you to get on a more even footing in figuring out what evidence is available to you. So that may or may not apply to the kind of litigation that folks on this presentation do, but it's one reason that I like FOIA a lot.
I agree, and because sometimes we are bound by administrative records, so I agree with that.
Great. I'm going to squeeze in one last quick question here. I think Elizabeth answered this, but perhaps Teresa, we'd like to see what your answer might be. Can a taxpayer get copies of their own returns from the IRS more quickly using a FOIA request or by using Form 4506?
Oh, don't use FOIA. Use the
4506.
Yeah.
Okay.
The outside procedures. Yeah.
That seems to be better. Yeah, that seems to be Elizabeth's experience as well. So wonderful. Okay, well, I think we have answered all of our questions. Thank you all for submitting them, and that's all the time we have. But before we leave, I ask all attendees who want CLE credit to stay connected for instructions to get your CLE certificate. Also, please wait for the evaluation to come up on your screen. To our faculty for this program, thank you so much for sharing your expertise with us. And on behalf of the ABA, I'm Janice Shee, thanking you all for joining us. I will now turn you over to our operator for some additional information.
Thank you. On behalf of the American Bar Association and the ABA section of Taxation, thank you for participating in this program. To learn more about the sponsors, visit the ABA website at americanbar.org. Thank you, and please click on the evaluation link. We value your feedback.